Legal Dilemmas, where you will find clear, concise legal advice. Today's topic is defining an occupation order. We have discussed various matters around domestic violence, and I'm going to ask Safina to define what is an occupation order.
Thank you, Brenda. Yeah, absolutely. So it's the theme that we're looking at is domestic abuse. So in terms of occupation orders, they come under the umbrella of the legislation of the Family Law Act 1996. And essentially, Brenda, an occupation order requires one party to leave the home or a defined area, and that can include the home as well. And that will obviously allow the other party to remain in the family home. It's often linked to a non-molestation order. Someone who is applying for an order under the Family Law Act 1996 would normally apply for a non-molestation order and an occupation order at the same time, but it isn't necessary to do that.
So does it exclude the other party from the house?
Yeah, absolutely. Essentially, that's probably the simplest way. It does act as an exclusion, but only, if the parties are associated persons, and we've already discussed what an associated person is. But apart from being associated persons, Brenda, they also need to be either entitled or non-entitled persons under the law. And to be an entitled person, you have to have a proprietary interest in the property. So you could be a joint owner or a co-owner, or joint tenant on a tenancy agreement. So you have to have some sort of entitlement to occupy the home. For example, you could be a spouse or a civil partner. And if you're a non-entitled person, you could be, a former spouse or a formal civil partner. You could also be a former cohabitant or cohabiting at the moment. But obviously, the court's going to apply quite a strict criteria.
So can you apply for a non-molestation order if you rent a property?
Sorry, Brenda, did you mean an occupation order?
Sorry, yeah.
It's okay. Obviously, you can apply for an occupation order if you are renting a property. I mean, the court's got to take quite a holistic approach to what they term all of the circumstances of the case. So they're going to look at things like housing needs, resources, finances, the effect on health, safety or well-being and conduct. When they look at the circumstances of the case, what they do is they apply the significant harm test, the balance of harm test. And what they're looking at is, is it better to make a particular order that will protect one party over the other party, even if they have, for example, to use what you've asked about, even if they're not actually on the tenancy. So yeah, they would be able to make an application. Whether it succeeds will depend upon all the circumstances of the case.
Will you have a stronger case if you have children?
Yeah, absolutely. Because if you think about it, just practically, Brenda, I mean, if you are expecting someone who may not be on the tenancy agreement but has got children to uproot themselves, the children would need to travel further afield to get to school. The court is going to take that into consideration. So the needs of the child will take priority, but that has to be balanced against whether the other party has somewhere to live or the resources to obtain alternative accommodation. And you know what, the court will be looking at things like, can they stop with a family member or some, a parent or a sibling or a friend, because that would be sufficient. It'd be more upheaval, both emotionally and physically, for the child and the individual who may not be on the tenancy agreement to uproot themselves. So the court is probably likely to grant an order, but obviously it's on a case-by-case basis.
And finally, how long is an order likely to last for?
Well, it's at the court's discretion, and obviously it will also depend upon whether you're an entitled person or an unentitled person, but it can be anything between normally 6 months. The court, I think that's sufficient time for people to sort out their accommodation difficulties and challenges, but it can be extended for an additional 6-month period.
Okay, thank you for that. That's a concise summary of the definition of an occupation order. If you are suffering, don't suffer in silence. Access the support services and apply for an occupation order if you have no other option other than staying in the family home, pending resolution of all matters. Thank you for listening, and please like, subscribe, share and comment on this video. Please have your notifications turned on to hear more great legal content.